Hi YouTube, my name is Natalie. I am a criminal defense attorney and I'm going to be explaining to you the denial of the petition for writ of certiorari that the Supreme Court just handed down today, October 6, 2025, to Ghislaine Maxwell. Ghislaine Maxwell was an associate of Jeffrey Epstein, and as a result of that was convicted in the Southern District of New York, the Second Circuit, of multiple crimes related to moving underage girls across state lines for the purpose of illicit activities. I have to say it like that because YouTube has very strict terms of service with the type of words we can use here. So bear with me while I try to get certain concepts across while not violating those terms of service. Now, the reason that this was denied is not always going to be 100% clear because they don't say anything other than granted or denied. But if a petition for writ of certiorari is granted, then the Supreme Court will consider whether or not to overturn someone's conviction in the criminal context. If it is denied, then that person's conviction is going to stand forever unless that person receives some type of pardon. Here, because this is in the federal court, the authority that has the ability to give a pardon would be Donald Trump. I don't know if President Trump will give Ghislaine Maxwell a pardon because it's completely up to him. It's completely his decision, but there are some indications that that is a possibility, that is not impossible, because Maxwell did meet with the Trump administration, and in preparing for that meeting, she received the benefit of being moved from a maximum security federal prison to a lower security facility, and I believe that she still remains there to this day. So as far as her petition for writ of certiorari is concerned, Ghislaine Maxwell was basically alleging that the federal government violated their obligations to keep with their plea agreement. So there is this case called New York v. Santabello, which is extremely important to all defense attorneys and prosecutors, which means that if the prosecution reaches a plea agreement with a party, they cannot go back on that plea agreement as long as the defendant does everything that they're supposed to do in carrying out that plea agreement. Let me give you a very quick example. For example, if the state offers a plea to second-degree assault and they say, as long as you do community service, we are going to recommend that you receive no more time in jail and that you get unsupervised probation. And the defendant does the community service, they come into court, and then surprise, surprise, the prosecutor is asking for 5 years in prison. That is a violation of what's called New York v. Santabello, which is a Supreme Court case that applies all across the country. And as a result of that, the person, the defendant, has to get the benefit of the plea that was originally promulgated. That is the case that Ghislaine Maxwell is relying on here in this case, and here's why. Ghislaine Maxwell and Jeffrey Epstein were originally looked at for prosecution in the 11th Circuit, which covers the state of Florida. So this was a Florida case in the federal government. So it was the 11th Circuit, that prosecutor's office for the United States. Federal prosecutors sitting in Florida, the 11th Circuit. Very, very important to notice that difference. And so what what Jeffrey Epstein did was he entered into this plea agreement where he would have to pay a bunch of money, and in return for that, the 11th Circuit prosecutors agreed not to prosecute any co-conspirators of his that were named. Clearly, Ghislaine Maxwell is a co-conspirator because that's why she's in prison right now. Well, he performs on the agreement in the state of Florida. He enters into the plea, he pays the money. The 11th Circuit does not prosecute anyone else in relation to it. However, the Southern District of New York, which is in the Second Circuit, also prosecutors within the federal government, decided that they were going to prosecute Epstein and his associates. So they prosecuted Epstein and they prosecuted Ghislaine Maxwell. Epstein was convicted. He eventually dies in custody. Ghislaine Maxwell goes through everything and is currently serving a federal prison sentence in relation to what she did within his organization. So what they were saying, Ghislaine Maxwell's attorneys, was this is one United States government, and this is one prosecutory body. So the case of Santabello does not cover if a second prosecutorial body wants to pick up and prosecute you, even though an unrelated prosecutorial body decided that they were not going to prosecute you under some type of agreement. They can do their own separate thing. So one would think that because the 11th Circuit and the Second Circuit are both circuits within the United States federal government system, and these prosecutors are all working for the United States, not the state of Florida, not the state of New York, that they would not be allowed to bring a separate prosecution after the NPA, the non-prosecution agreement, was entered into by Jeffrey Epstein. However, where Ghislaine Maxwell has been unsuccessful over and over again in all of her appeals is a case called States v. Anabi, or Anabi. I'm not sure how you pronounce it. Annabi. It is cited as 771 F2D 670, and it's a 1985 case that was decided out of the Second Circuit, which is where the prosecution was brought. Specifically in the Second Circuit, it says that case says that the different districts and circuits, those prosecutors can reach their own independent prosecutorial decisions. More specifically, Anabi says that a plea agreement binds only the office of the United States Attorney for the district in which the plea is entered unless it affirmatively appears that the agreement contemplates a broader restriction. So just because, let's say, the federal prosecutor's office sitting in Wisconsin decides that they're going to reach a non-prosecution agreement with the defendant doesn't mean that the federal prosecutor sitting in California has to abide by that. The same thing here. Just because in the state of Florida, the 11th Circuit prosecutors decided that they were not going to pursue any of the co-conspirators of Jeffrey Epstein does not mean that that binds the Southern District of New York, the Second Circuit. And that has been good case law, like I said, since 1985. So what this means is that the Supreme Court does not want to overturn that case law. They want the different prosecutor bodies in the different circuits, although they're all within the federal government, to have the independence to be able to bring prosecutions if laws impact their state. So on the federal level, but they're still impacting their state. Like, it's okay if Florida doesn't want to prosecute you, but in the state of New York, we want to prosecute you. And it looks like what the Supreme Court is saying is that they don't want to overturn that. And politically speaking, Ghislaine Maxwell would not be the type of defendant that you would want to overturn that law on. There was an amicus curiae brief. So amicus curiae, a friend of the court brief, basically organizations and individuals can write briefs to the Supreme Court urging them to or not to take up a case. And there was one here from the National Association of Criminal Defense Lawyers in support of the petitioner. Basically, the National Association of Criminal Defense Lawyers, they wanted the Supreme Court to take it up because they want there to be consistency across the different circuits, saying that if you get a promise not to prosecute in one circuit, we're not going to prosecute you in another. The United States is the United States. You have to remember that these different prosecutorial bodies, they all call themselves the United States. They're all representing the United States government. They just oversee different parts of the United States based on the circuit that they're in. And so that's the reason that the NACDL wrote that brief in support of her, not because they support any of her actions, but because they wanted it to be a test case to try and get consistency across the federal system. However, this is just not the right defendant, in my opinion, to make that type of change in the law. And there will always be a time where the federal government kind of contradicts itself. You know, in one state, they do things one way, in another state, they do things another. And you could test it out with those cases, but I think politically speaking, with Ghislaine Maxwell, this is like a hot potato that nobody really wants to touch. What do you think? Do you think that if you reach an agreement with the federal government in Florida, that they should have to follow that agreement in New York? Or do you think that all of the appellate courts and the Supreme Court got it right here, that she reached that, or that Jeffrey Epstein reached that agreement in Florida that only applies to Florida, the 11th Circuit, and therefore it was fair game for the Southern District of New York to prosecute both Epstein and Maxwell? Let me know what you think in the comment section down below, and I'll talk to you later. Bye.